Today, we're going to dive into the Liberals' appeal of Justice Mosley's Emergencies Act decision from January 2024 and what it means for the rights of all Canadians to oppose the actions of their government. The Trudeau Liberals have just finished their appeal of a significant federal court ruling on the almost 3-year anniversary since the government took excessive and violent action against the Freedom Convoy in February of 2022. These massive demonstrations against vaccine mandates and government overreach were the most ingenious, grassroots, and free-loving civil rights movements of Canadian history. And instead of meeting to hear the repeatedly ignored concerns of Canadians, Justin Trudeau feigned COVID-19 and went into hiding. Then the government cracked down like a totalitarian regime and beat protesters to a pulp, trampled them with horses, and seized and searched their assets without any oversight or judicial review, leaving Canadians feeling betrayed and slighted by their own government. A little over a year ago, in January of 2024, Justice Richard Mosley ruled that the government's use of the Emergencies Act to end the protests was unreasonable, and thus the actions it took to quell the protest infringed on the constitutional rights of those harmed. Ultimately, the decision found that government, through the Governor and Council, failed to meet the legal thresholds for declaring a national emergency and, crucially, violated Canadians' civil liberties. So why is this appeal so important? Well, let's break it down. In 2022, the Canadian government invoked the Emergencies Act to address the disruptions caused by the Freedom Convoy, or so they say. Here, though, are a few snippets of my coverage at one of their last stops in Ontario before reaching the nation's capital of Ottawa at a truck stop in Port Hope. These are the happy, joyful, and freedom-loving people the government and mainstream media framed as, well, domestic terrorists and national security threats.
This group is a threat to our democracy. What we're seeing is bigger than just a City of Ottawa problem. This is a nationwide insurrection. This is madness.
What brings you out to Freedom Convoy 2022?
Hey, let's do it. Everybody standing together. We were just saying the other day, we haven't seen everybody come together like this since the Raptors won the basketball, so it was really great.
I'm a fired healthcare worker, and I stand up for what they're here supporting. Yeah. So enough of the tyranny.
We're willing to listen, definitely. If they're open to talk, we're willing to listen.
The government has since tried to justify the invocation of the Emergencies Act on February 14th, 2022, as a means to disband border blockades at various ports of entry, arguing that they constituted a national security threat, an escalating situation of violence and lawlessness that needed to be controlled. But based on submissions heard this week on February 4th and 5th, this was based on speculation and suspicion, not grounded in evidence or facts. And what's more is that the government relied on feedback from the United States about threats to trade if the border blockages or, in many instances, inconvenient slowdowns persisted. What I heard throughout the defense arguments on February 5th is that the Liberals were basically just embarrassed by the success, ingenuity, and effectiveness of the Freedom Convoy protests, and instead of addressing these concerns of the protesters, they took unprecedented action and measures to save face with the United States, our largest ally and trade partner, who is now threatening tariffs and pulling out of Canada anyway. So here's the kicker. Justice Mosley ruled that the situation didn't meet that legal threshold to declare a national emergency. His decision pointed to the fact that the protests, while in some instances disruptive, didn't pose an immediate threat to national security as defined by Canadian law. Now, the government, specifically the Justin Trudeau Liberals, are investing millions of taxpayer dollars to appeal that ruling. They're saying that the risk was real. This wasn't just a few trucks blocking roads. According to them, the protests were out of control, spreading across the country and becoming a major national security issue. One of the most controversial aspects of the Emergencies Act was the freezing of protesters' bank accounts. The government argued that these drastic measures were necessary to protect public safety and national security. But the original applicants in the court filing from Kristen Nagel and the Canadian Frontline Nurses, the Canadian Civil Liberties Association, the Canadian Constitution Foundation, decorated war veteran Edward Cornell, and dedicated police officer Vincent Gerses and more are pushing back. They hold firm that freezing bank accounts without clear, compelling evidence is a violation of Section 8 of the Charter that upholds privacy rights and the right to be free from unreasonable search and seizure, arguing that this was not saved by Section 1, delineating reasonable grounds because there were no reasonable grounds. There was no evidence of a national security threat. But really, imagine waking up to find that your bank account was frozen for days, no way to appeal it, no idea for how long it would be frozen, and you're left far away from home in many instances in the dead of Canadian winter with no money or access to your own funds. How is that even legal? And what's more is that defense maintains that freezing the bank accounts of protesters actually prevented them from being able to leave the area like the government wanted, without money or access to necessities like food, shelter, and gas. In the case of Cornell, he was thousands of kilometers out of province from his home in New Brunswick and relied on the generosity of fellow Canadians to help him get back there. The same ones painted as far-right extremists and white supremacists by the ivory tower-dwelling laptop class and media. Provinces like Alberta and Saskatchewan stepped in as interveners in the Liberals' appeal of Justice Mosley's decision, arguing that they had the resources necessary to handle the situation within their borders. And they told the feds that very fact when consulted by them, thus maintaining that the federal government overstepped its authority when they invoked the Emergencies Act unnecessarily. Alberta, for example, pointed to the situation at the border crossing in Coutts, where local authorities were already dealing with the protests, saying they didn't need the Emergencies Act to do so. This is about more than just one protest or one court case. It's about setting a precedent. Should the government have the unchecked power to suppress its citizens when they express political dissent, or should it be held accountable, forced to address concerns, and prevented from using wartime legislation to violently infringe upon the right to assembly and free expression, seizing assets and financial resources in the process? So what's next here? Well, the outcome of this case could have lasting impacts on how the government handles future protests and how flimsy the definition of a national security threat can be. As one of the lawyers put it, the ability of the government to act now and ask questions later, or, in some instances, never. If the Liberals' appeal is successful, it could redefine the balance between the government's supposed security measures and the freedoms Canadians hold dear. And whether we like it or not, it affects all of us and any future ability to dissent against the government. For Rebel News, I'm Tamara Ugolini. The Emergencies Act case continues to prove that Trudeau's actions have undermined our democracy and left him drunk on power. If you want to see an election called immediately, then please go to calltheelection.ca to demand a change in government. Sign the petition calling for an election at calltheelection.ca.